The judges erred in holding that the framework for the housing levy as set out in Section 84 does not meet the requirement of Article 201, 206, and 210 of the Constitution, and the principles of good governance, transparency, and accountability required by Article 10, 2A, and C of the Constitution. It is therefore our submission, if I may summarize, that the Court of Appeal's decisions to deem the issues surrounding the interpretation of Section 84 as moot effectively dismissed the constitutional issues raised without adequately addressing their continuing relevance and their potential impact.
The Attorney General wishes to make the following suggestions as to what the court should bear in mind. First, the court should bear in mind the fact that the purpose of government is to deliver services to its citizens. That is why government exists. Government levies taxes so it can then provide service to its citizens. Government is then not involved in any other enterprise other than service delivery to its citizens. Secondly, the Republic of Kenya is a limited democracy. And a limited democracy, I submit, is a form of government in which powers of elected representatives or leaders are limited by law and the Constitution by imposing specific constraints to prevent abuse. Legislation plays an important role in a limited democracy. And I submit so, members of the court, because legislation enables what government can do, and at the same time, it constrains what government can do. Government can only do what legislation under the Constitution enables it to do. In the absence of legislation, government is then unable to provide services to its citizens.
The framers of the Constitution did not want Parliament to appropriate for CFS items. Constitutional CFS items takes precedence. And as regards to the Constitution, the appropriation is an inferior act. And because of forex fluctuations, change in the interest rate, change in macroeconomic situation, and the revenue being estimated, we cannot for certain match item by item. And that is where the court actually got from. I think the question we believe the High Court should have asked is whether the estimates, the budget estimate, which is the estimates of expenditure, whether the estimates of revenue, loan and grants, whether the appropriation and the Finance Act was sequenced within the law, or before were tabled in accordance with the BFM Act and the Constitution. And were they before the High Court? And this is an issue that we want the court to correct the record because it's an issue that High Court, as I said, found for our client, but it's an issue the High Court found for our client erroneous, and said actually that you must have there must be a rate in the appropriations. We don't do that. In fact, that will be circumventing the constitutional architecture because these are estimates, they haven't crystallized, and other expenses takes precedence.
The National Assembly is to be congratulated in the manner in which it processed the 2023 Finance Act, because it took time, it made the facilities available for public hearings, and 800 people appeared. They made their representation, none was turned away. In fact, there has been no claim that any person presented an email that either was rejected or that was not considered. So as we retire and consider this issue, I would invite the court to look at this report that has been produced in the replying affidavit of the clerk, that the Court of Appeal did not consider or even mention anywhere in its judgments in arriving at its conclusion. Had they considered this report of the committee, then that decision would have been different, because if 13 out of 1,080 are the only ones, which is like 3% out of the presentations that are made to the National Assembly would then nullify a Finance Act, then would be asking for the National Assembly to respond 101% to all the memoranda. They did, and they did a splendid job, and the court should make that recognition in its judgment. Whether Parliament has an obligation upon conclusion of the public participation exercise to provide detailed reasons for accepting or rejecting views, and whether failure to give reasons vitiates the legislative process and invalidates the legislation passed. Honourable Chief Justice, just want to make the following submissions. One, in the judgment of the Court of Appeal, when this issue was considered by the Court of Appeal, the issue turns on whether Article 10(2) of the Constitution on transparency and accountability was violated in the enactment of the Finance Act. What you'll find in that judgment of the Court of Appeal, in those 20 or 30 paragraphs that were considered by the Court of Appeal, in coming to its determination, the Court of Appeal did not consider the evidence tendered by the National Assembly through the clerk and the Speaker of the National Assembly on what was the outcome of the public participation. Because had it done that, because if you read the judgment of the Court of Appeal, nowhere do they refer, so they said they had read the whole record. They do not make reference to the report of the Committee on Finance and National Planning on what the outcome of the public participation was. Now, when you retire and go and consider, you'll find the following. 1,080 memoranda was submitted to the National Assembly. 300 there were 300 representations that were made, and there were emails that were presented to the recommendations and submissions that were made to Parliament. Out of all this 1,080, the report, which is a very detailed report, and you find it in the National Assembly's record in volume 64B, volume 65B, and volume 66B, at pages 9522 to 9779, you'll find that the committee considered all the memoranda, item by item. And the first one, which is it's incidental, I think it was by coincidence, was by Anjarwala and Company Advocates, a firm of advocates. All the suggestions that they made were considered item by item. And this went all the way on these 3 volumes. And they considered all the, and some of the proposals made by the public were accepted, some were rejected. And they did not do it wholesale. They went item by item. So you find the same proposal is made by more than 10 of the members of the public or institutions that and stakeholders that are presented before the National Assembly. Nowhere does the National Assembly dismiss any suggestion by saying we have already considered this. They considered each item individually, and some had 20 recommendations, some had 2, some had 3. Even the emails that have been sent to the National Assembly with one proposition that please get rid of this Finance Act, they were answered, and Parliament said, we have received your email, we'll pass it to the committee for consideration. The Court of Appeal was under duty to consider how many of these proposals were considered and how many were rejected, in making that sweeping determination that there was failure to account or to be transparent, because that is not true. Out of all these recommendations, 97% were dealt with in the report. On the legality, whether the court has jurisdiction to test the legality of policy positions, we have made extensive submissions, Honourable Chief Justice. But I want to make the following submissions. One, policy is within in terms of tax revenue measures, that is within the mandate of the national government through the National Treasury, as well as Parliament on the legislative reforms that will be passed. Now, how these tax revenue measures are to be implemented, that is within the mandate of the National Assembly through its committees and the Committee of the Whole House. The courts from the High Court, the Court of Appeal, and the Supreme Court on the first question, can they test the legality of the policy positions? Yes, it can confirm that due process has been followed, that there was public participation, that they met the statutory timelines, that they adhered to what the PFM Act, the Public Finance Management Act, stipulates in terms of the budget making process. Anyone can challenge that. That is not in dispute. But where we depart from the decision, and the High Court got it right. I don't need to go into that much. Mr. Mahat went into it. The High Court got it right. When it comes to tax revenue measures, courts, just not in this country, but globally, have been very reluctant to step in to direct the government and parliament on how to proceed. So the question is this, and this is the second question that the court has asked. If the court contests the legality, it can. The second question is more important. If so, whether the impugned section of the Finance Act relating to various tax legislations are unconstitutional, there the evidentiary and legal burden is on a petitioner to demonstrate, item by item and clause by clause, that this particular item infringed this article of the Constitution, and as a result of this policy, infringed this article of the Constitution, and as a result, it is unconstitutional. That is a burden that you cannot make sweeping statements. You must identify item by item and the article infringed. And when you do that, then the court can intervene and then determine that this is not compatible with the Constitution, or there's no rational, it does not serve any rational, there's no rational justification under the law of the Constitution. To that extent, it's possible. And as to the particulars, the KRA will address you, but there's a very limited jurisdictional mandate for the courts to intervene on tax and legislative measures to raise revenue, because that is within the mandate of the National Treasury and the government of the day. The court only has to ensure that in doing so, the public participation is undertaken and there's adherence to both standing orders, then the statute and the Constitution. So the intervention can be only very limited.
Now that we have found our way to the apex court of our republic, it is our very humble view that this issue ought to be resolved with finality. Because despite the enactment of the Affordable Housing Act, the underlying legal issue remains significant, because finance law will continue to be enacted into the future with subsisting affordable housing legislation in place. And therefore, we will be inviting the court to find that the Court of Appeal acted in error, and that this issue is alive, and that this issue should be determined.
The finance bill is not one concerning counties. It is one that seeks to raise revenue at the national level. And thirdly, and finally, with regard to this issue, once the two speakers of the two houses have reached concurrence, then with respect, the courts should be very slow to accede to any invitation to interrogate either the process of reaching concurrence or the end product, which is the concurrence itself.
Maybe you can speak. I find out if it's okay now.
Yes, you are. It's. I think the interference is not on my device. It's safe to proceed.
Very well, thank you, Kansas.
Was raised in the High Court. The High Court sidestepped it. Did address
We
it.
cannot stop you, Mr. Omtata, from raising an additional issue if you so wish.
Yes, we may, my lady. Thank you very much. Timelines and the presentation of the budget estimates and the finding that a right has been breached or a procedure has not been.
We'll agree how to share it. You need not use all of it when you will continue to complete your submissions within that 1.5 hours.